Hi viewers, I'm Zach Berly here with Carolina Forward, where we talk to our elected officials, or in this case, our judges, about the issues of today, the future of our state, and why it is that they are motivated to do what they do. I have the great privilege of being joined today by Associate Justice of the North Carolina Supreme Court, Justice Anita Earls. First of all, Justice, thank you so much for your time.
Oh, thank you.
It is truly a privilege to have someone who has served the state, and not just through the courts, but also otherwise for so long. And I just want to start off with that. It can't be just a decision you make off a whim to become a judge. I imagine that's quite a big decision for yourself. How did you get into becoming a judge? I mean, from going from law, what's that decision like, and why did you make it?
Right. Well, I had been litigating civil rights cases for 30 years. In a variety of settings, and in 2016 it began to be clear to me that for the short term our federal courts might be a challenging environment, and that we ought to also pay attention to state courts when it comes to protection of our basic rights. Yeah. That our state constitutions are a rich source of understanding about how the legal system should protect people's rights, and so that's what kind of turned my sights to state court. And in 2018 it was just an opportunity to put myself forward to say I would like to have a different role, to step away from the role of advocate representing parties and step into the role of being on the court and wrestling with the legal issues. So I'm actually really grateful to the voters of North Carolina for giving me this chance to serve.
You talked about your work in civil rights law, and I would just love to talk about your role in the founding of the Southern Coalition of Social Justice, and the role that you played in what was one of the most determinative times in American history.
Well, I had been at what was then the UNC Center for Civil Rights, and I was working with Julius Chambers. He was director of the center at that time, and I'd been there about 4 years, and it just became clear to me, and this would have been in 2007, that there needed to be more places for law students who were interested in doing civil rights work to be able to do that work. And I wanted, so people would look at the national civil rights organizations, maybe the Lawyers Committee or the NAACP Legal Defense Fund, but I felt it was important to have a place in the South that would work regionally. So the Center for Civil Rights only represented people in North Carolina because it was a creature of the UNC system. But I felt like we had a lot in common with people in South Carolina and Mississippi and Alabama and Florida and Tennessee. It was really important to work regionally and to have an organization where law students who graduated and wanted to do this kind of work could stay in the South and represent communities of color, represent low-income communities. So that's what energized me to try to create that opportunity.
Amazing. What about you personally? What brought you here, and then what maybe about yourself do you think was most important in forming this love for law, as far as coming here and deciding this is the path you wanted to follow?
Well, I came to North Carolina to work with Julius Chambers' firm. When I was at law school, Mel Watt, who at the time was at the law firm, was also a Yale Law graduate, and he came up and told all of us starry-eyed law students about his firm and Julius Chambers' work. And so I had not, prior to that, really I hadn't lived in North Carolina. I'm from Seattle, Washington originally. But I knew that when I went to law school, I knew that I wanted to do civil rights work because of my family situation, growing up in a mixed-race family. So hearing about the law firm in Charlotte and having the chance really to follow in Julius Chambers' footsteps and to work with some of the brightest legal minds and the best legal advocates was an incredible opportunity at that time.
For yourself, you're obviously becoming a judge in this state, maybe as opposed to the federal level, is something you have to run for. You have to run an election. For yourself, what is it like running for that office? I mean, that's something that typically with our circuit courts and our federal courts, it's not something that you do, so it's an unusual circumstance. What is it like putting yourself out there to become a judge, but also as a woman for yourself in a field that also intersects with politics, two areas that are heavily male-dominated, heavily white-dominated?
Well, I had previously, when Senator Hagan was first elected in 2008, she had a very open process for federal appointments to the U.S. Attorney's offices and to the federal district court bench. And I had actually put my name forward at that time and gone through an interview process, and she had put me on a list of 3 names for the Middle District. So I went through that process, and that was actually a very political process. So, in my experience, the only difference is who are the decision makers and how big is the pool that you're trying to appeal to. So it didn't seem a huge leap. Obviously, when you're appealing to all the voters across the state the size of North Carolina, that's a lot larger than the influencers and decision makers around who gets a federal appointment. But both were intensely political processes, and I always feel a little sad when I hear so many people disparage running for office. I enjoyed it. Yes, there were parts I didn't like. I told people I became a telemarketer and I had to call, be on the phone and try to sell myself. But the process of talking to voters, whether it was on the phone or in person, the process of talking to them about my values, what I saw the importance of the role of the courts in our democracy, and why their vote mattered, that was just a continuation of the voting rights work that I had been doing for 30 years. And so I felt really fortunate. I was able to so I had a year during which I was a full-time candidate, and I could only do that because I had, a financially supportive spouse who would let me not work for a year. And so I recognized, I think that's an important point, that our politics makes it hard for people who can't be self-sustaining for a period of time, makes it hard for them to participate, and we really ought to change that in some way. But nevertheless, I couldn't have done that earlier in my career. For a time, I was a single mom supporting my son on a public interest lawyer salary, which is not a big firm salary. So there were plenty of periods in my career where I could not have taken a year off and run for office. But now, finally, sort of 30 years in, I could. And it was an amazing opportunity, and I really value and cherish the experiences I had going around the state, talking with voters. And if I can just say one more thing about why it was great. I had practiced law and brought cases for clients in communities across the state, and to go back and connect with people I'd represented, or people who said, here's what happened to our family, or here's what happened to our neighborhood, here's what happened to our county after the case that you brought was finished, was really amazing. And I was really surprised the number of times I'd be speaking and it'd come to question and answer time, and somebody would raise their hand and say, well, I remember when you represented my uncle, or that was incredibly rewarding. So I think that you can approach politics and campaigning with a positive attitude about the value of reaching out to ordinary folks, listening to them about what their issues and concerns are, and it can be a very positive experience.
Now, this could just be recency bias, but it seems that there has been a much larger focus on our courts in the last couple of years. Naturally, due to decisions that have made at the federal level. For yourself, do you feel that? Do you think that that's true, that people are paying more attention now? And is it necessarily a good thing? It's a good thing that people are informed, but also some of the attention hasn't always been positive that's been paid, not just in this state and at the federal level, but overall.
Well, absolutely. I think it's so important that people pay attention to what's happening in the courts, and to remember that not only statewide elections for our appellate judges, but your local judges. And if you care about the criminal justice system, you're electing district attorneys, you're electing judges, you're electing the people that run the system. And so knowing what they stand for, and knowing about them and caring about who's running for those offices, I think really makes a difference. So I think that in North Carolina, there's been sometimes there's been more attention to judges than other times, but because we do elect in this state, I think there's always been perhaps more attention here than states where the judiciary is fully appointed.
For yourself, this state has gone through a big change recently as far as not just the composition of the court, but in other areas as well. There has really been a change, a shift, I would say. For yourself, how have you seen that shift play out in the court, both with the cases that you deal with and just everyday life inside the court?
Well, certainly there's been a change on our court that has had a tremendous impact on how our court sees its role and how it operates. And I think it's important that there not be misconceptions about how our court has acted. And so I actually took a really close look. And you know, we act officially through our opinions, right? The legislature passes laws, we issue opinions. And I think that the media covers the laws a lot and only some of our opinions. And so I took a look at the court's opinions over the prior 2 years. So from January 1, 2021, which is when Chief Justice Newby was sworn in, so a change in the leadership of our court. But this is a court that was 4 Democrats, 3 Republicans, from January 1, 2021 to December 31st, 2022. 2 full years of opinions. We issued 328 opinions during that period. 222 of them were unanimous. So 2/3 of the time, all 7 of us agreed. But the notion that both sides are being partisan is not borne out by the data. So in those 2 years, the 3 Republicans on our court disagreed with each other a total of 7 times in 7 opinions. The Democrats on the court disagreed with each other 48 times, okay? So 48 to 7. And then the cases were split along party lines. That means all the Republicans together, all the Democrats together, only 43 times. So the Democrats on the court disagreed with each other more often than the Democrats and the Republicans lined up against each other. There were 8 cases in which everybody disagreed with everybody else.
Yeah.
But my point is, if you're looking at who is behaving in a partisan fashion on our court, even when our court was 4 Democrats and 3 Republicans, there's a stark difference in that, those patterns in our cases. That's looking at all the cases and counting when, you know, sometimes we concur, so you might have an outcome and a justice thinks the outcome's right, but for a different reason. I counted those as agreeing. But it's important for the public to know that there is a difference in how in those 2 years, how the justices behaved while on the court.
That's fascinating. I think there's a natural inclination to think of our courts as nonpartisan, but of course, naturally, we have partisan elections in North Carolina, and there are other states that do this. What impact do you think that has had on public trust? Because I want to talk about that larger as well, but just with the elections, when people go and say, oh, well, the courts are nonpartisan, but then I'm having to go and vote with someone with a D or an R next to their name, just in general, how do you think that affects how people view the court and its legitimacy?
Well, I feel like I don't know, you know, I'm not sort of a researcher who looks at public opinion or what might influence public opinion, so it's harder for me to say how that influences the public. What I can say about that question is that, well, I'll say 2 things. I am someone who's done a lot of voting rights work and looked at what do voters need to be engaged and to participate in the process. And the partisan label appears from voter behavior to be important to voters. Now, right or wrong, I've always said our democracy is about people voting for whatever reason they want to, but having the right to vote, having their vote counted, and having their votes count equally, weigh the same weight. Those are the fundamentals of a democracy. And so there's a sense in which I feel like if voters say, I care about those labels, then, you know, we shouldn't consider it wrong to provide that information to voters. And why do I say they care? The last time we had a nonpartisan election for this court was in 2016 when Justice Mike Morgan ran. In that election, the Court of Appeals races were partisan. So the judges running statewide for the Court of Appeals had a D or an R after their name. The one seat that was up that Justice Morgan ran for, the 2 candidates for that seat did not have a D or an R. They were no party designation. And a full 500,000 voters voted for Court of Appeals and did not vote for Supreme Court,
Wow.
even though the Supreme Court race was ahead on the ballot, right? Like typically you think voters, like, they go so far down, they get tired, they stop voting, right? So that's why you see a difference in vote totals. People skipped over fully, I think it was 400 and something thousand, but close to 500,000 voters skipped over the Supreme Court race where there was no partisan label. Now maybe there was some, again, I didn't do any like political science research that I can say with statistical significance that this is the reason why, but that's certainly to me an important fact. So then what does that mean about what voters should think about our court? And on the one hand, I think we get confused about what we mean by partisan, because all of us have values and beliefs, and but I think the sense when you say partisan, to my mind, you're acting as to act consistently with your values and beliefs is actually what we think is integrity, right?
True.
And so, I'm going to have values and beliefs, and they're going to align more with one party or another. That's just like a fact.
Yeah.
Partisanship, I think, is where your loyalty is to your party, and you'll do whatever the party says, even if it actually doesn't align with your values and beliefs. That I can see why voters would say that's a problem. But so if what they're concerned about is judges aren't supposed to have values and beliefs, well, that's unrealistic.
Sure.
And that's, a lot of the research and science around implicit biases tell us that the way to address them is not to pretend they don't exist. So the best judge is not one who says, I am completely impartial, I have no views, I just call balls and strikes. That's actually not the way to be impartial. The way to be impartial is to say, I grew up in this culture, I have these stereotypes and assumptions. Let me make sure that I'm not necessarily applying them here. Let you make sure that I am countering those and coming at this with an open mind to the best of my ability. That's how you are impartial. And I think you can judge our court's impartiality by, again, looking at the opinions. And so, looking at which justices in criminal cases, which is half our docket, which justices sometimes rule for the defense and sometimes rule for the state, and which justices only forever rule just for the state and against a criminal defendant. That's, I think, how you can measure impartiality.
That's a remarkable insight, and I think an interesting way to think about it that so many times we don't. And I'm glad for that correction on partisanship.
I didn't mean to correct, but
No, I think that was a great way to put it. One of the other things that so often is faced by courts is sometimes the legislature shovels things on you, and maybe they know it's gonna get struck down, or maybe they hope it's not gonna get struck down. Whatever it is, regardless. Let's say that the legislature passes something, and then you have to turn it down as unconstitutional. And then there, not just in this state but other places, are claims of legislating from the bench, and you hear that a lot, whether it's Republicans or Democrats, because you hear it on both sides. For yourself as a judge, do you just kind of have to block all of that stuff out and say it doesn't matter what political lens they put on it, we just have to do the job regardless of what you think it is? How do you manage those claims of legislating from the bench?
Right. Well, so as a fundamental principle, on the one hand, we absolutely apply the presumption of constitutionality. So we presume, as a starting point, that everything the legislature does is constitutional. So anyone who comes to us and says, wait a minute, this statute conflicts with the Constitution, they have the burden of proving that, okay? But the second thing to know is that North Carolina, our judiciary, this court, the predecessor, not mine, but in in the 1700s, prior to the full ratification of the Bill of Rights to the U.S. Constitution, issued an opinion called Bayard versus Singleton, and it's a really fascinating history. It's an interesting case about whether or not people who were formerly British subjects and didn't agree to swear loyalty to the newly formed United States, whether they could own property in New Bern. Okay,
yeah. And
in that case, the Supreme Court said that they had the power to review acts of the legislature to see whether they are in conformity with the state constitution. At that time, there were people who argued, no, 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 the courts don't have that power. I think those arguments are resurfacing, and so to see arguments that our court really shouldn't be a check on the legislature is historically an argument that was made and did not carry the day. I think that from my perspective, I swear an oath to uphold the Constitution of this state, not to necessarily only uphold what the legislature does. And we also, under the Code of Judicial Conduct, are supposed to not pay attention to public clamor, right? We're supposed to have the courage to rule properly, even if it's not popular. And I think in the past, people have thought about that, in criminal cases where there's a huge public outcry over a very heinous crime, and a judge has to rule in the case even if the public, wants a particular outcome. But it arises, I think, that same principle, that as judges we are supposed to be immune to the public clamor, applies in these cases as well. And I remember very vividly in one of our oral arguments, which are now all on YouTube, so you all can go back and fact check me on this one, but during one of our oral arguments, a counsel made the point that the court should rule a particular way because to do otherwise would raise this specter of being accused of legislating from the bench. And my question of that advocate was, why should that matter? Why should we care about that? We're here to the best of our ability, read the Constitution and determine whether the laws are consistent with it.
We saw very recently in Wisconsin, there was a very expensive race for the state Supreme Court there. In fact, the most expensive race there has ever been, I think, anywhere for a court seat. There also was a lot of polarization over stances and that sort of thing. I mean, it was really a very traditional campaign that you would see for any other office. Do you think that is the future of state judicial races, where there is just massive amounts of money and there are clear lines drawn? I mean, I think maybe maybe in the past it's always been this way, there's just been less money, but do you see the future of judicial races following the path that we've seen in a state like Wisconsin?
I would say not entirely, and for two reasons. So Wisconsin's unique, right? They have these, their statewide judicial races in off years when there's nothing else on the ballot. So quite naturally, that means there's a lot of attention focused on it. In the presidential election years, when there are judicial seats on the ballot, they're just not going to get the same airtime. They're not going to, the political dollars are going to be flowing towards the presidential race and the governor's race and the U.S. Senate race if there's one on the ballot. There's just so much else. State legislative seats, county commission, there's so much on the ballot that it's just not realistic to think that judicial races are going to have the same kind of intense focus for money and every other way that Wisconsin's race was. Second reason I say not entirely is because we have seen multiple instances in this state where the most money didn't win the race. And so, for example, if you look at the contest in 2020 between then Chief Justice Sherry Beasley and then Associate Justice Paul Newby, the candidate with the most money didn't win. So I think that there's a point at which more money doesn't necessarily win the election, and that donors and candidates and other groups that spend money know that. And the other thing that I think we should always keep in mind is how the ways in which voters get their information is evolving. And so the big, expensive, traditional TV ads, there's plenty of people who don't have regular TV. And so messaging and getting the word out to voters happens in different ways. So I do think it's a wonderful thing to have attention on the state judicial races. I'm not sure, that the Wisconsin is going to become the norm.
Fair. I wanted to ask, because you would likely have a unique view on this or insight on this because of your law background, but there has been a lot of discussion at the national level and somewhat at the state as well about the Voting Rights Act and the Civil Rights Act and the kind of the re-looking at it of, well, it's color neutral, which I think if you have any idea of the 14th Amendment, it's pretty hard to say that. But there has been a kind of a revision or a re-look at some of those laws. And of course, the Voting Rights Act has a very huge impact in our state. Just on that topic as a whole, when looking at those and the amount of cases that are coming up to courts all over the country about that, do you have any particular insight or thoughts on that continual raising of the Voting Rights Act and its kind of evolution by courts over the years?
Right. I think my perspective would be to look at the process that led to the 1965 Voting Rights Act. And from my view, it was a very back and forth between people on the ground in places like Mississippi and Alabama and in the South who were trying to get voting rights established, and they were looking at what the barriers they were facing were, and the people in Washington who were crafting the legislation. So I think it was a very, and it wasn't the first Voting Rights Act. Earlier ones were sort of not getting the job done. So it was I think it was a very grassroots motivated legislative effort that resulted in what the 1965 Voting Rights Act created, and that we need that same kind of effort to craft effective legislation now in this arena. So that's my biggest takeaway about sort of where we need to go. We need to have communication from people on the ground who are out there working with voters and seeing what the barriers are, to then for Congress to figure out what's necessary to improve our democracy. And I think it's a vitally important undertaking because we're just in this very contentious time where the possibility of our democracy is really at stake.
Yeah. For yourself to see the erosion of faith in the judiciary and to see that people having very strong opinions about what the judiciary should look like in the future for state and federal areas. I mean, you're on the front line, you're literally in the courtroom, and to see this big shift in people saying that it's not servicing the will of the people or that it's not faithfully executing the Constitution. And that's not stuff that's in your hands, I realize,
right.
But for yourself to see that, how does that make you feel as someone who's literally in the courtroom in the midst of this battle that we see waging?
Right. No, I'm very glad you asked that question because it is incredibly challenging right now. I can't remember a time when litigants, it used to be, I lost my case, but I respect the process. I had my day in court, we'll live with the outcome. And that general sense of we have structures, we have processes, we respect the outcome without undermining the legitimacy of the institution would sort of be business as normal. We are no longer in business as normal world. And for example, to see a day after the victory of a candidate in the Wisconsin Supreme Court race, that candidate, politicians in that state to be talking about impeaching that judge before they've even been sworn in, this is the kind of attack on the legitimacy of the institution that I don't think serves us well. And so it's up for grabs now, whether as a country and as a society, whether we will dial back and uphold the basic principles of the institutions that our democracy is built on, or whether the forces that are trying to tear them down will be successful. I think it's there's a book, How Democracies Die, which has been certainly influential in my thinking and really highlighted that it's not a foregone conclusion. We can't take it for granted. And what I try to do is to hear from people about what do they think our judicial system should be providing, and how is it falling short. I think that I think it's valid for people to have a perspective about that, and I fear that for too long in our politics, the concept of lock them up, right? Like that is so many political ads are about who locks them up and who doesn't, and lock them up is what our judicial system is supposed to guarantee, and I think that is such a bankrupt and morally empty vision of what our justice system actually is supposed to be. And what I would replace it with is what I campaigned on, and that is equal justice under the law. That's what people want. They want to know that there is a clear system of laws that are applied equally to everyone, and that whatever side they are on as an individual, they'll be treated fairly and equally when they come to court. That's what our system should guarantee, and when and where we are falling short, we shouldn't be shy about saying it, and we shouldn't be shy about fixing it.
For yourself to know that there is so much of a focus on this state and cases that are going on nationally and cases that you're going to be facing, what do you see for the future, just the immediate future coming up, as far as how the situation is going to continue to develop for this court and for this state, just as the judiciary as a whole? How do you see the future nearby going?
Well, that's an interesting question, and I think it's hard to think of the court in isolation.
Yeah.
Right. So we are impacted by what is happening in the politics of the legislature and the administration in this state and nationally. I do draw hope from examples where I think courts have pulled back and been the guardrails that we need. So, a lot of the cases that were brought alleging election fraud, and courts saying, well, no, actually, we need evidence, okay? So the courts became the one place where facts still matter. So I draw hope from that. And of course, I draw hope from the younger generation. And, I just see young lawyers from across the state and across the country who are eager to bring us back to a place where our politics reflect their values and where we have a more inclusive democracy. So that's my hope for the future.
Justice, I want to thank you for your time, for your commitment, not just during your time with the court, but throughout your entirety of your life to, as you mentioned, an equal vote, a fair vote. I think that so many times we focus on figures that are in not the courts, but I think it's very important to look to people like you and people that aren't justices as well, people that are lawyers that are out there fighting every day for the basic rights that we have. I think that we oftentimes, you are often sometimes shrouded by other areas, and we don't recognize people like you as much. So I'm so glad that we had this opportunity to speak with you, to hear from you, and to recognize you as well for the importance that you've played in law and justice and the fair vote and the rights of North Carolinians, people, the larger United States as well. So thank you so much for your time and your commitment throughout your life.
Well, thank you for your really important work in getting word out to the public, and so really appreciate that.
Folks, this has been another interview with Carolina Forward Interviews. We thank you so much for your time. Please view our others and more in the future for so many incredible people who serve this state and all of us as citizens of this wonderful place. So thank you so much for your time, and we'll see you in the next video.